Yes.
With this lordship.
Yes.
Lordship, in item number 11, lordship. I'm paying adjournment on behalf of Mr. A.K. Gupta for respondent number 2 and 3, lordship. A.K. Gupta is out of station, lordship. Can we fix it on Monday or next week, any date, lordship?
What is the issue here? Have you taken consent?
Yes,
Yes,
lordship.
I am for the petitioner, Lordship.
Adjourn. When?
Lordship may kindly have it on
2nd week of January. First week of January. 2019.
first week of January. Oblige, Lordship. 7th of January.
Bless.
Oblige.
May I please, I'd like to mention item number 8, my lord. For that day, my lord. We have
Right.
difficulty on today, my lord.
Difficulty on?
Yeah, my lord, need it on next week, my lord.
Okay. Not December. December last part.
Oblige, my lord.
May I please, your lordship?
Hmm.
May I pray for 16 and 17 may come up first week of January.
First week of January.
May I please, your lordship? My lord, I beg to mention item number 15.
1-5.
The petitioner has asked us not to appear. May be allowed to withdraw the wakalat.
That is up to you. Our permission is not required. There is a procedure. You will have to issue notice. Then withdraw.
Will follow the
You
necessary.
are MS?
TJ Sahewala.
Ms. TJ Sahala submits that the petitioner has withdrawn the brief from their chamber. Accordingly, press for some time to do the needful for deletion of their name from the cause list. Prayer is allowed. List January. Yes.
May I please, your lordship? Lordship, I beg to mention for listing criminal petition for admission, lordship.
Which year?
23, lordship.
20?
23, lordship.
It is not the bench. You go to the appropriate bench.
May I please? I'll mention item number 13, my lord.
Item number?
13, I am for the respondent. With due consent, my lord, the other side, I be allowed to file affidavit in official.
What is the matter about?
NI Act, relating to NI Act, my lord.
NI Act Quasman.
Yes, my lord.
What affidavit is required?
There is something, my lord.
Item number 13.
13, my lord.
Okay, on the prayer of the learned counsel for the respondent, matter stands adjourned and be listed in the 3rd week of January.
May I please, your lordship? I beg to mention listing of an IA in a criminal revision petition, my lord. The IA was filed for expeditious hearing of the revision petition.
Which year?
2017, my lord. However, my lord, some facts were inadvertently left out in the IA. Hence, we want to withdraw the IA, my lord. So next week, any day, my lord. Oblige.
Receive the papers.
I have not received from the registry, however, I have collected.
We are giving you some time
Hello,
properly, not today. Give a date as per your convenience.
this month, madam?
This month only.
Wait, madam.
As per your convenience.
This month.
You are available?
I am available.
Okay, give a date. Today we are with some
Well-
other matters, delivery of judgment, correction, many things are there. Just I want to understand in such a situation what is to be done for future course of action. Maybe in this case, judgments is there, but how to deal with the facts of this case? Subject to what everybody says, a little high-handedness was there on the part of this officer. At the same time, the magistrate has also not applied its mind. Sorry to say, this is a preliminary view. That's why, so that we can arrive at a just decision, that's why we have requested you.
Right.
Only for that reason.
Right.
Because decision should be just. We should not tilt to any side, but uphold the law.
Yeah.
That's why we have.
I would like.
Yes, instruction. 2 days time to complete instruction.
My lord,
Whether notice is served. See, we passed an order on 1911. Mr. Bothakur said that he will complete his instruction as regards service of notice through concerned police station. Upon respondent number 2. Okay. Status of service of notice through concerned police station. Notice was sent to the respondent number 2 through the office of the learned public prosecutor.
my lord,
This is recorded on 1911.
my lord,
Okay.
my,
Such order was passed on 12/2.
my lord.
See, registration takes for issuance of notice to the father of the victim, shown as PW3 in special case number so through the officer in charge of Soraipung police station.
My lord.
This was an order passed on February 2024. Okay. So thereafter on 1911, we again granted time to complete Mr. Bothakur on 27/11/2024. On 27/11/2024, Mr. Sharma submitted that he gets 2 days time. Now we are on today on 30th.
My lord, allow me sometime today
Yes.
itself, my lord.
You-
Today
you-
itself.
yes,
Today,
you-
I just make a
just-
query, my
You
lord.
just go through the
My lord.
orders.
My lord. Today itself.
Yes, Mr. Sakya. Same in terms of its earlier order dated 1911. You go through this order
My lord. my
and
lord.
give
Yeah,
us the
today
instruction.
itself, my lord.
Then we'll appoint somebody and get this matter heard.
My lord,
Huh?
my lord.
Because these are the sexual offense and all. So therefore, we cannot say that not
My
necessary.
lord.
Okay. So tentatively, if it is nothing is there or service is completed, we'll appoint somebody.
Am I cast?
If not also, then also we'll appoint
My
somebody
lord.
for on behalf of the victim.
Right.
Then we'll fix this matter for hearing any date. This is a 2019 matter.
19.
We are not in so hurry, but only difficulty is that in his case,
My lord.
the person is inside jail. So we'll have to give a first preference
My lord.
immediately. Okay.
6 years, 9 months.
Maybe in the first case, I think he's also he will be inside jail, which is a jail appeal.
Really.
So these two matters will give preference. You have to obtain instruction,
My
will
lord.
appoint somebody and do this. Yes.
My-
May it please your lordship. Lordship, in this matter, my senior will appear through VC. But yesterday we have request for a VC. The link has been sent, but today it's showing some glitch in the link, lordship.
There is some problem in our system, no? So he'll have to come physically, no out. Otherwise, there is some technical difficulty.
As a Supreme Court matter, so lordship.
Maybe. See, we cannot help. It is an advantage to all of us. No problem on that. We are inclined to allow learned counsels to argue through VC. But if there is a technical glitch, VC is not happening, then of course we'll adjourn today, but we'll have to arrange this matter tomorrow or day after tomorrow. Not tomorrow. Tomorrow I will not come, I suppose.
Next week, your lordship.
Yes, next week give a date.
Lordship, then
2013. We want to finish this 2013. Give a date. 4th of December. It is submitted that Mr. BD Kaur, Learned Senior Counsel, was supposed to address through
item 14 as
but tell him that this court is having difficulty. So even if we are willing, but we cannot. And at the same time, we'll have to make a balance. These are matter of 2013.
trying only.
Yes, sir. Tell that. Item 3 and 14, no?
14.
Mr. BD Kaur was supposed to argue through remote VC. However, due to some technical glitch at the end, at this court's end, he could not be present. Accordingly, matter stands adjourned and be listed
Okay.
4th of December.
Obliged, your lordship.
So that day, your lordship asked me to give a type copy, but it is there, my lord. I have showed it to Coastmaster on that day.
Where is that?
Page 32, my lord, type copy is there. Flag is there.
31, type copy.
Yes. My lord, while accepting the FR, the learned court passed the order on the Naraji petition to investigate by different officer again. And your lordship asked me to find out a judgment of the apex court, my lord, regarding that also I have brought, my lord.
What it says?
Vinod Tyagi, my lord, this is the judgment. They have no, magistrate has got no scope, my lord.
So this is the impugn order.
Yes. Under 173, magistrate cannot do it.
Heard. Mr. S.C. Biswas. I passed a judgment in your case, in an earlier case.
Similar.
Yes. The Silchar Judicial Magistrate.
Oh, then I have applied for the copy, my lord.
What is it?
His name is Sujit Ghosh.
Sujit Ghosh. I have signed this order long back. Kindly bring that. Why should we write all the legal proposition each and everything?
Very
That
good,
was
my
against you. Now this will be in your
Even
favor.
then, the person comes is a district judge. So he will ask me, give me the judgment copy. Perfect.
Heard Mr. Biswas, learned counsel for the petitioner. Also heard Mr. Spencer, learned additional public prosecutor. Though one Azmal Hussain and Mrs. M. Buragohai has entered appearance on behalf of respondent number 2. None appears for. Huh? Huh? Okay, okay. The present petition is filed under section 482 of the Code of Criminal Procedure 1973, assailing an order dated (18/6/2012), whereby the learned who is the magistrate?
He is a judicial magistrate, first class Karimganj.
Learned judicial magistrate first class
Karimganj.
Karimganj
Yes.
refused to accept the final report submitted by the investigating officer in connection with Karimganj Police Station case number 21/2012 under section 366 within bracket A/387/34 IPC and directed for a fresh investigation by S and separate officer. Full stop. A brief fact to leading to filing of this petition is that respondent number 2 Bishas,
Yes.
this case I subsequently dealt with. In a different issue where there was either quashment of FIR or against warrant of arrest or framing of charge. After this investigation continued.
No.
Is there any stay?
Yes. There is a stay in this case.
Are you sure?
But the order is there, my lord.
Order is there, but why, or the order, is there no investigation, no
it was
charge
not
sheet?
continued. No. I have already talked. Nothing has been done.
No petition is filed.
While the guard also got married, she has become mother also.
No, we know that.
Yes.
That's why I'm saying, how could I deal this matter somehow? A boy from, without opening the file, I'm telling him. There was a love affair between these
Yes.
two. Then he was in Saudi Arabia. Then he came back. Then she alleged that she was kidnapped. She was taken to her house from a market with a e-rickshaw or something like a vehicle or Maruti van. Then she was taken to the house. She was beaten up. She was raped, what not. And I concluded and quashed, I think, the FIR or something like that, saying that this is absolutely improbable. There is a relation, everything. Why I recall this?
Yes.
Isn't it? Without opening the file, I'm telling you.
I don't know how.
Which case? Who was the lawyer? That is different.
I cannot say, my lord, actually.
You have a confirmation.
Sure.
The unnecessary, then in view of that, exactly similar. I could not remember the facts, but I dealt with a similar case, and this was the story. I have not even opened your file, and I have not gone through this last night also. I have stopped looking at files because of that the lawyers are taking adjournment.
On that day, Advocate Giyasuddin was there. We have the respondent number 2. Today he has come.
Call him, Mr. Giyasuddin.
I will call him.
Call him. Let us see. Maybe similar incident. Maybe, but
There is a love affair. They fled away. They got married, and my lord, the father has filed a case. The girl produced before the magistrate. She said, "No, we are love affairs. I have gone on my own ways, and I am major."
this is
Yes.
okay. Then it is a different, because in that case, girl says that I was kidnapped from the market, and the villager says that no, she herself has came to the residence.
Your father said that my daughter was kidnapped.
Okay, your daughter has not alleged.
No.
Then it is a different case. But exactly Saudi Arabia, staying at Saudi Arabia, love in Karimganj, and then it was a case of kidnap. It was alleged by the girl. She said that I was in market by a auto van, Maruti van. She was kidnapped and a residence. All the 161 statement. It was case of discharge. I recall now.
Oh,
Yes.
Vishwas might be.
Then all these persons, no, not discharge. All the persons, 161 statement, villager stated that no, I saw her coming together into the house on her own. So that's why I was. Okay, this is different.
Still different.
The girl has not alleged.
No.
Okay. Saudi Arabia, that's why maybe all these allegations. Yes. বিশ্বাস Learned Council also heard Mr. Nan appears when checking থাকিল আগত এইখিনিও থাকিল present application leading to the case is that one, the respondent number 2,
Father of the victim.
Azmol Hussain lodged an affair filed a complaint case before the court of learned Chief Judicial Magistrate inter alia alleging that the petitioner had kidnapped the complainant's daughter and there was an extortion call in connection with the release of the informant's daughter. Such application was forwarded by the learned Chief Judicial Magistrate to the officer in charge, Karimganj Police Station, with a direction to register a case and file a final form. On the basis of the aforesaid, accordingly, Karimganj Police Station case number
21/2012.
21/2012 under section 366A/387/34 IPC was registered. The statement of the victim was recorded before magistrate under section 164 CRPC. The aforesaid statement is part of the record and quoted herein below. Where is that?
Page 19, Annexure 11.
Page 19, Annex 11. From the statement under 164 to CGM Karimganj. Full stop. Subsequently, final form was filed in the shape of a closure report. Full stop. Closure report.
Page 26, my lord.
Closure report. Being aggrieved by such final report submitted by the investigating officer, the informant father lodged a Naraji petition and the learned magistrate by the
Order dated
order dated
8/6/2012. 8/6/17.
18/6 or 8/6.
8/6, my lord.
Where is the 8/6? Page?
Page 31, my lord.
That is 18/6.
Yes, 18/6, I'm sorry. 18/6.
18/6. Once, thereafter, the learned magistrate once again recorded the statement of the victim on its own,
But she has changed her entire statement. Said that I was forcefully taken away. And I'm
second, and accordingly, she deviated from her earlier statement and in the aforesaid backdrop, a re-investigation was directed by another officer. Full stop. By order dated 18/6/2012. Reinvestigation was carried out.
no, because of the stay order. it should not.
Okay. Okay. Full stop. Being aggrieved, the present petition is filed. It is by now well settled that in the well settled that which paragraph? There is a certain what can be done, what not cannot be done, where
Yes,
given.
yes. এটা আছে তোমার জানা রে।
There is such in this judgment specifically. Which paragraph, Mister?
My lord, your lordship may come.
No, the entire discussion was summarized in a paragraph in this case. In Binay Tyagi versus Irsad, Elias Deepak and others reported in 2013 5 SCC 766, the Honorable Apex Court laid down the following proposition of law, paragraph 40. Huh? Paragraph 40. 40.1, 40.2. 40.5, 40.6. In view of the aforesaid settled proposition of law, this court is of the view that in the given facts of the present case, where during where the victim in her statement recorded under 164 admitted it to be a case of admitted to be admitted to have a love affair with the accused, as well as admitting that she is more than 18 years of age. In the considered opinion of this court, the learned magistrate could not have recorded the statement of the magistrate once again on his own, on his own, full stop, and ask for investigation, reinvestigation by a different officer, full stop. The magistrate, it is needless to say that magistrate is within its right not to accept a final report filed by investigating officer and shall be within its power either to take cognizance on the basis of the material available on record, comma, to direct for further investigation for the reasons to be recorded. If magistrate is satisfied and can register the objection petition to be a complaint case and proceed accordingly. However, none of the aforesaid course of action has been taken by the magistrate, rather directed for a reinvestigation by an independent, by a different investigating officer, which is not within the power of a magistrate and as held by the Honorable Apex Court in Binay Tyagi Supra. In view of the aforesaid, this court is of the view that the learned magistrate has committed patent illegality and serious error of law. Accordingly, this court is inclined to exercise its power under section 482 CRPC to set aside the aforesaid order dated Swenchu, ordered accordingly.
So, third lordship.
Yes.
Lordship, there is an offer from them, Lordship,
Ah.
Mr. Dubey, that he's a scientist, Lordship, Indian Institute of Science and Technology, Lordship. He's a
Who is scientist?
myself.
Complaining is a renowned scientist, lords.
Okay, then.
Then he's willing to pay the amount, lordship. So without
Deductions, my lord, that what we had proposed.
proposal. So he actually, if we go for a trial also, we know the fate, lordship. It will
Okay,
continue.
so
Right,
both of them advise them, close it.
Yes, that's what I
No,
have
not
advised my
closing,
client.
lordship.
Even he has received the advance money because of certain things he could not proceed. And when he make a claim, he made. me
Now,
that-
what is the proposal of both of you today?
Today, lordship, matter, actually, we need some time, lordship. How many days, 10 days?
My client is ready subject to you.
7 days, lordship. 7 days.
The present application is filed seeking quashment of complaint or affair.
FIR.
Quashment
GR
of
case, my lord.
quashment of GR case number
5979
for quashment of GR case number
5979 of 2011.
5979 of 2011 arising out of CID PS case number 38/2010 under section 420, 468, 120B IPC. The FIR fundamentally discloses some the allegation of fraud and cheating arises out of a claim of money, full stop. In the aforesaid backdrop, both the learned counsel submits that in the meantime, the accused petitioner has offered to compensate the informant, and they are in a process of a negotiation. Full stop. In the aforesaid backdrop, the learned counsel for the informant, respondent number 2, submits that he may be granted 7 days time to complete his instruction, as well as to complete instruction and to settle the dispute, consider the proposal given by the informant.
They found
In view of the aforesaid, matter stands adjourned and be listed on
lordship.
10th of December.
2 days later, my lord.
Yes,
I'll be
12,
out.
12,
13 or 12.
12 or 13.
13th of December.
Highly obliged, lordship.
Do settle it.
Yes, yes, no, that's what I, because there's no civil suit or
He is a
arbitration
great
as
scientist, lordship. He's a
That's why you let him be great once again.
he is a awardee scientist. So I obliged, lordship.
my client is a seasoned litigant.
Lordship knows his
See, I never handled this client, but this is a known name in the cost list from our days.
In civil case, lordship.
From Diganto Das to Rakesh Dubey. And maybe from the earlier PK Goswami, Niloy Datta, who is not. I never handled, but this name is very
When I was
familiar in.
appearing before, just Chandru Chaudhary then. Question was asked when a matter came. Sir, he is still that ferocious lion. I said the lion has been tamed.
Lordship.
Deep down.
Yes, Sakya, what is this?
So related to this matter, my lord, another criminal petition, that is, my lord, 82 of 2015 is pending, my lord. I pray that both matters come up together in the
Please
next.
tell us what are you saying?
Here, my lord, the FIR has been lodged against this, my lord, petitioners. In that case, my lord, their my lord, final report has been submitted by police. After filing final report, my lord, they have come up with the complaint
Naraji.
case.
Complaint case.
Complaint case with the same facts and circumstances. In that complaint case, my lord, we are discharged. Then thereafter they have come up with a Naraji petition in the against that final report. After that, then my lord, the court has taken cognizance. we have challenged that, my lord, by way of a criminal petition before this report in the year 2015. That is pending. Thereafter,
That
my
is
lord,
pending.
that is pending. my
Okay,
lord.
then.
Then, my lord, subsequently in the year 2017, they have now this time the debtor came up with the same facts and circumstances, another criminal petition. My lord. That is, my lord, what we are here.
You are challenging.
challenging.
Where is the other matter?
Other matter is, my lord, pending, my lord. That is also in the admission stage, my lord. It is pending, my lord.
I list this matter. It is here in this case. Today it is listed. Other case.
No, not listed.
We'll take together.
Let's see, I am
Legal aid council.
for respondent number 2 in this case, let's see.
Be here.
And-
We'll hear you.
And in other case, mother of respondent number 2 is there as.
Somebody maybe might have appeared there. But it is interest according to him. These are connected.
Let's see.
If it is connected,
Let's
let us decide both the matters.
Whether mother has received notice. I
That
don't
we'll
know.
see.
Let's-
Therefore,
let's-
instead of deciding in piecemeal, list this matter along with criminal petition number
2015.
criminal petition number 82 of 2015 on this is a 13-14. We'll finish it up within this year.
So then let it come on 12th, my lord. This is a hearing day.
Musmi 13th. All this 8 Musmi 17, 18, 19 we can go to January dates, but up to 16 within December. No adjournment beyond that.
Let's say on 13, I have some.
Okay, tell us
problem.
your date.
Any date?
12. 12.
Let's- God bless. Whether notice has.
We'll see.
received,
We'll see. We'll see on that day.
I cannot represent mother.
No, no.
That is also in the admission stage, I think.
That is the year to that is also to year 2015.
That is
Okay. Now this is item number.
Fine, my lord.
Yes.
Please, Lord.
Yes.
This application has been filed under section 482, my lord, for
Mm.
passing of the, my lord, order of NBWA and a proclaim, one order is issued by the, issued against the petitioner, my lord, as proclaim offender, my lord.
Where is the order?
Order is at page 12, my lord. That is the order of NBWA. The type copy, my lord. 16/12/2010, my lord. Was absent, my lord.
You are Saidur Rahman.
Saibur Rahman. The FIR has been lodged by the father of the victim, my lord. The FIR is registered under section 79, my lord. After, my lord, we have taken the
Charge sheet file under.
RC file under 366, my lord.
Okay.
After, my lord, we have appeared once, my lord.
Mm.
That is in case
Any examination
examination, my lord.
of witnesses?
Kindly peruse my page 13 once, my lord. Page
Yes.
number 13. my lord. It is an order of 24/8/2010. After the charge sheet has been filed and case has been registered as session case number 86/2009 before the additional sessions Nagaon, my lord. The PO is on transfer. Accused Saidur Rahman is present. No witness are present. Issue fresh summon to the material witnesses, my lord. Thereafter, my lord, what happened, my lord? In the meantime, my lord, we have an agreement with the informant, my lord. There is a presumption that the case will be settled mutually, my lord. Then the accused did not appear. He thought that the case will be settled, my lord. An agreement also executed, my lord. In the year thereafter, my lord, 2015, my lord, he has been declared proclaimed offender. And 2018, the police came to his house, pursuant to 2015 order. My
But why should we allow you were you did appear?
Yes, my lord, I did appear.
Then
on
why did
24
you remain absent?
My lord, on the presumption that the, my lord, case will be withdrawn by the informant, my lord.
Why case will be withdrawn?
My lord,
All
case-
material, all statements are against you.
My lord, kindly peruse page 19, my lord. There is an agreement between the informant and the accused, my lord.
Informant cannot enter into an agreement on behalf of a minor. Metterance there.
The time of execution,
That's why you should be behind bar, because you have already influenced the father to compromise. You are influencing the witnesses. Both the witnesses specifically stated. She stated that I was kidnapped. I was taken some village I do not know, where after 10 days I was recovered.
informant himself has filed an affidavit before this honorable court, my lord, stating about the.
Informant will ask the authorities to register against a case against him for hampering and tampering with the witnesses.
Otherwise, I am ready to face trial, my lord. Since there was, my lord,
You may say
My
that may
lord.
be an acceptable
my lord,
argument,
I'm ready to
but
face
don't say that compromise. We'll ask him also to proceed against him also. How can he compromise on behalf of his minor daughter who has been kidnapped?
At the time of lodging the FIR, she is 17 years, my lord.
Then how can he compromise?
Was date on 24/8, my lord, he has appeared there. Presumption that, my lord, otherwise he is ready to face.
Hard. The learned counsel for the petition. Also hard. It's a Swenso additional public prosecutor. The present application is filed. Assailing an order dated. Orders dated. Where are those?
My lord, page 12 is the issue, NBW issued against him. Page 12 and page 15, my lord. Order dated 16/12/2010, 24/6/2015, my lord, on the same page. And page 15, where the accused has been, there is a proclaimed offender. Order dated 19/9.
Where page?
Page 12, my lord. 12/2010. W issued against the accused, and 24/6/2015, my lord. PW and PN.
Swenso. The present application is filed assailing order dated 16/12/2010 and 24/6/2015. By order dated 16/12/2010, NBWA, non-bailable warrant of arrest, was issued against the petitioner, who is accused in
My lord, session case number 86/2009.
Sessions case number 86/2009. By order dated 24/6/2015, PNA against the accused petitioner was issued. The brief fact is that
One more order, my lord.
And
2015, page 15, my lord.
page
Page
15.
15, my lord.
Another order under challenge is 19/9/2015, which discloses that when P&A issued against the petitioner returned with a report that he was not found in the address in spite of several offense, the learned session judge issued proclamation and attachment. Isn't it?
Yes, ma'am. As per
Declaring him as a proclaimed offender. The prosecution was lodged on the basis of an FIR lodged by respondent number 2. Is that it?
Yes, madam.
Respondent number 2, who alleged that on 2/3/2009, his minor daughter, aged about 17 years, was missing from his residence, and after inquiry, he could learn that around 11 p.m., his daughter was kidnapped from the courtyard of his house by the present accused petitioner. By the accused petitioner. Fact remains that subsequently the victim was recovered. It is also first of accordingly investigation was started and victim was recovered from the residence of the petitioner. Is that it? Residence of the petitioner. The statement of the victim was recorded under section 161 CRPC, and having found materials, the investigating officer submitted charge sheet being the charge sheet is submit. Accordingly, the submit in GR number 49 of 2009. The matter being triable by the courts of session, same was committed, and session case number
86/2009, my lord, pending before the my lord, additional session judge.
86/2009 was registered, which is pending for adjudication before
Additional session judge number 1, Nagaon, my lord.
additional session judge number 1, Nagaon. Full stop. Though petitioner initially appeared in before the learned trial court
On 24/8/2010, my lord.
on
24/8/2010, my lord.
24/8/2010. However, subsequently he defaulted, and accordingly the impugned orders and in the aforesaid backdrop, impugned orders were passed. It is the contention of the petitioner that he did not appear as an agreement was entered between the informant and informant that they will not pursue the case. Otherwise, the accused was willing to face the trial. Full stop. Face the trial. It is referring full stop. It is on record that the respondent number 2, that is the informant, has also filed an affidavit in this proceeding and contended that the affair was of the year 2009 and his his daughter has in the meantime got married in the year 2011 and presently having married happy peaceful married life, and therefore married life, and the accused has never disturbed the informant, his family or his daughter after the incident of 2009, and therefore he is not inclined to pursue this matter. Full stop. Be that as it may, this court is not inclined to enter into the merit of such contention, inasmuch as merit of the contention. However, taking note of the stand of the informant that he was under misunderstanding that case is not proceeding in view of the stand of the informant, this court is inclined to grant, this court is inclined to dispose of this writ petition, criminal petition with a liberty to the petitioner to approach before the learned assistant session judge and session judge, taking all possible ground for non-appearing, for his non-appearance before the trial. And in the event such application is filed, the learned trial court shall consider the case for recall of the NBW as well as proclamation on its own merit, without being influenced by any of the observations made by this court, and taking note of the attending facts and circumstances that may be presented by the accused petitioner. Full stop. Accordingly, it is directed that the accused petitioner shall appear before the learned trial court within a period of 2 weeks, give a date within 2 weeks. So within 12th of December 2024, and file necessary application in this regard. Full stop. Application till this regard. Till such application is decided, the NBWA / order the orders that orders that it went and the order that it went to last order proclamation shall remain suspended.
I'm
The
deeply,
LCR be returned back.
I'm deeply obliged.
These are 20 and 21 years. Her radiological age is 20.
20. That's right.
No medical evidence, no physical, recent sexual thing, or no injury in private part. So let him take all these takes, but we cannot say in a case, we cannot enter into this merit of this case. That is the best will be the trial judgment. And up to him what he ground he takes.
Obliged, ma'am.
LCR be returned back forthwith.
I mean,
What is the issue here? Tell us.
in this case, Lordship, the impugn order, Lordship, kindly Lordship peruse impugn order dated.
What was the offense?
Lordship, 211 Lordship, IPC Lordship.
What is 211 IPC? What is 211 IPC?
False charge, Lordship, false charge of offense made with intent to injure Lordship. Lordship, may kindly peruse Lordship the order, Lordship, 1/12/2018 Lordship. Here in this case, Lordship, the petitioner Lordship filed a case, Lordship, against.
So you have lodged a false FIR.
This is the allegation, Lordship.
Not allegation, this is the fact. Here is a false FIR by you. Then you entered into a compromise saying that this is false. When final report was submitted, notice was issued to you, you said that yes, FIR was false. So magistrate is left with no option but to proceed against you under 211. What are the primary elections? 376. Then people like you should be punished, as simple as that.
But
You
there
will
is a
bring in somebody saying that I have been raped and subsequently say that this is a wrong thing. 211 rightly done.
But in this case,
Most misuse by people like you. Who will argue? Ahmed or HR Choudhury?
Yeah, Lordship, my senior.
HR
director,
Choudhury.
In this case, Lordship, this is a violation of section 340 and 195.
340?
340, Lordship.
So you want to say there are procedural lapse. What is this? How is the 211 is to be taken?
Lordship, in this case,
Give
Lordship,
us, let us see. CRPC.
last occasion, Lordship, in one case, Lordship, criminal
Just a
petition
minute.
586, 2022, Lordship.
Yes, tell me.
Last occasion, Lordship, in one case, Lordship, criminal petition 586, 2022, Lordship, dealt with all the legal issues, Lordship, in this.
Give us that, sir. So I have committed already a mistake. Huh?
Rightly, Lordship.
I have already committed a mistake. Oh, that case. So it will under that provision. 211 will come under that chapter. Matter ends there then. Show us that provision that it will also come under 211 is under 195.
Lordship.
Which section? 340?
340, Lordship.
340. CRPC, is that it?
Yeah.
340. 340. You have taken the right judgment. May be wrong, but for you, I have bound by this judgment. 340?
Lordship, procedure in cases.
340?
340 CRPC, Lordship.
340. Ah. 340 CRPC. How do you get that 211 will come under this provision? Tell us.
Lordship, Lordship first, 195, Lordship first.
195 CRPC? Yes. That we know, 340 procedure we know, but we want to know that 211 comes under 195. That is what I am asking.
Lordship, in 195.
195. Tell us.
195 subclause. Lordship 1 subclause B, Lordship.
195 subclause B.
B1.
Any of the offences punishable under any of the following sections of the Indian Penal Code, namely 193 to 196, both inclusive. 211 offences alleged to have been committed. So, no court shall take cognizance of any offence punishable under so and so, except on a complaint in writing of that court or by such officer of the court as the court may authorize in writing in his fair some other. Hard. Where is that order?
Imperial order, Lordship, page 18, Lordship.
Page
19.
Page 19.
Lordship 19. Page 20.
It's done it, but in a different way.
Page.
It is not asked to lodge an FIR, but asked directed to treat a
Complaint, Lordship. Page 21, Lordship.
complaint.
Order the copy disorder. of this order be treated as complaint.
Then what happened? It was taken to custody.
Okay. Yes, sir.
Now it was sent to CGM Bongaigaon.
Addition, page 18. Page 18. Page 18, Lordship. Inquiry has been initiated and
What is your argument? What 195 says? Why we will not treat that order as a complaint?
Lordship accept
He has not taken except on a complaint in
In
writing
writing.
of that court. So that order he has treated, said that this is what happened before me. So this is my observation, this may be treated as complaint. So accordingly, CGM treated it to be complaint. What wrong?
but Lordship in the definition.
Will it be, what do we mean by a complaint?
Lordship definition, Lordship.
What is the definition of a complaint?
2E, Lordship.
Huh?
2E, Lordship.
2E. 2E. Let us see. This is an interesting case, 2E.
Or 2D, Lordship, sorry.
2E.
2D, Lordship. 2D.
Hmm.
Complaint means any
So
allegation.
where is that complaint? CCCD 2E.
Lordship D, Lordship.
2D.
D, Lordship.
Okay, 2D. Complaint means any allegation made orally. So even an oral allegation is complaint. Or in writing to a magistrate. So here he has written an order and addressed to a magistrate, that is Chief Judicial Magistrate, with a view to his taking action under the code. He has not taken, but he has requested the CGM to take action that some person, whether known or unknown, has committed an offense but does not include a police report. Okay. So would you want to say that it has come to his knowledge? If we go by definition of complaint, he has written that it is to be treated as complaint. This is the allegation, what he has done. Now it is sent to the magistrate. Magistrate accepts it to be a complaint. What is wrong in this? Come prepared tomorrow. Not tomorrow, Monday. Why it will not be treated as a complaint? Because the magistrate might have committed one mistake, that is take into custody, that he could not have. Because he is the complainant. He is not acting as a magistrate. It has come to his knowledge and he has seen that this is happening. This is according to him is a wrong thing. 211 is committed. So he sent it to the Chief Judicial Magistrate. Just as a whole, I am saying, I am not taking any view. So complaint in writing, it must be complaint in writing or oral.
Yes.
Huh?
Witnesses are also there.
Or oral or witnesses. Complaint may allegation may oral writing to a magistrate with a view to taking his conduct that some person, whether known or unknown, has committed the offense. So what he says, this is the person during course of things. Suppose I get an thing today that somebody has sworn a wrong affidavit. What I can do? Either I can ask my Registrar General to raise a complaint, because ultimately I have to pass an order. Why should he register a complaint? Or I may say that this is the fact, take it to be a complaint and send it to the magistrate. Registrar General send it to the magistrate. Maintenance there. In this case, in Nepotrium, case was that the magistrate, the session judge, said that he has committed an offense under so on and so forth. So therefore register an FIR.
Yes, sir.
195. He was offenses are 195. Register an FIR. We say no, you cannot. It must be in a complaint and not on a police report. So if cannot be police report, it must be a complaint. Now, what should be the form of complaint is not disclosed. So you will have to argue a case that complaint must be in a complaint form, but in that time you'll have to show us that this is the form of complaint.
There are a number of witnesses of.
Where do you get that? Where do you get that?
What order?
In 211, where do you get it? Tell us.
Fix a date, Lordship, then.
We're fixing a date. That's why I'm giving you a chance.
As part third, Lordship.
Part it will be part third till January. Everything is part third. Monday. Come with homework. He's already writing for Monday. Tuesday. These are the important cases you get. Already decided is this, but here we have defined a complaint also. But I say, okay, complaint may be in this form, but in this case, FIR was directed to be registered. He says, no, you cannot. There is a distinction. I'm keeping this judgment here. So you find out something, how a magistrate or a court is to proceed in case of a 211, more particularly by a magistrate or a judge. If you get hold of something that no, there must be, then it's different.
Lordship, in this case, there in 211, Lordship, the
Mm.
word mentioned the criminal proceeding, Lordship.
Mm.
Probably, Lordship, the proceeding starts after charge, Lordship, after taking cognizance, Lordship.
So subsequent order magistrate has taken cognizance. That may be there, maybe that cognizance is taken on what basis? If it is a complaint, there must be an inquiry under 200, 202. That can be your ground of argument.
Proceeding starts, Lordship, after taking cognizance. Lordship. But in
Proceeding
this-
starts under
in this-
taking
in this case-
cognizance.
In this
So-
case, Lordship, cognizance not yet taken, Lordship.
No, cognizance not yet taken, but cognizance for taking a cognizance under complaint case, there must be an inquiry under 200, 202. Because that is a complaint only. That can be your argument that the complaint is by the additional subjudicial measure, something like that, to the CGM. Now CGM, because it's filed by a magistrate, cannot automatically take cognizance. The procedure is to be followed because this is to be so far relating to treating it as a complaint. I do not find anything subject to what you argue on Monday. Second phase may be that yes, this is a complaint for the sake of argument, but whether proceedings is followed. And if proceeding is not followed, what should be the fate? We'll set aside the whole complaint, even if materials are there, or we'll send it back to the magistrate. This will be the third question. Tuesday. What is this?
Please, your lordship.
Yes.
Lordship, this is a matrimonial disputes.
Mm.
Lordship, initially there were talks of settlement were going on. In 2022, we sought time, they sought time to file affidavit, and we also said that talks are going on, we'll file short affidavit. But thereafter, Lordship, they filed a maintenance application that has been withdrawn till date, no divorce from either side. So I will be praying for a short date that we want to file an affidavit. My clients are from Haryana,
You want to file an affidavit for compromise?
not compromise. We want to bring on record subsequent development. Lordship, in 2019, when the CRP criminal petition was filed, Lordship, the all offense occurred in the state of Haryana. The wife came to Assam in the district of Kokrajhar, where her brother was temporarily posted. She lodged an FIR there. Now they are not residing in Kokrajhar. So warrant were issued against us. We came before this court challenging basically the territorial jurisdiction.
That is gone.
That has gone after Rupali Devi.
After Rupali, that is gone.
That is gone. So other facts are also there, and we need to address that.
Because
Matrimonial dispute.
Rupali, after Rupali Devi,
Yes,
that
we
part
are-
is gone. I think I have also delivered a judgment.
This was filed before that.
just
Maybe.
before that.
Maybe, but this is a beneficial declaration by Supreme Court. Will
We
give
understand.
them.
So as far as territorially is concerned, we will not touch that issue. But there are other issues because entire family has been entangled. Even the maid daughters. That
Yes,
issue
maybe that. Yes, what you say?
Your Lordship, I'm appearing on behalf of respondent number 2.
Please tell us what is your case. What is the present status? Are you where are you staying? With your husband or somewhere else? Is he giving maintenance? Not giving. You do not know who is your senior?
Look at this.
Huh? PK Das.
Yeah, no, there are only two respondents. You cannot be for four. Private respondent only.
Are you aware that you are appearing in this case?
PK Das is there, Your Honor. That is true.
Let's go to PK Das.
This is for respondent number 1.
Respondent number 1.
Yes, madam. If he is not here, we will proceed against you, or you will have to be prepared. Are you having the brief? No. Your senior is having the brief? No.
Emergency.
This is how young lawyers are being trained.
Day before yesterday, Supreme Court has passed a recent judgment on the same issue on 26th.
What is the
Entire family was entangled.
that no recent judgment is required.
Yes.
See,
Otherwise,
omnibus statement
yes.
will not do.
That
So
is
far
what I
relating to
want
this
to bring.
498A.
Yes.
Omnibus statement will not do.
That is my case.
If that is your case, what is the judgment? We have delivered a judgment.
Gita Malhotra. Yeah. Otherwise, earlier we used to rely upon Gita Malhotra. And
No,
this,
no, all dealing with all this judgment, I have passed a judgment on this point regarding Rupali Devi and involving others. Of course, it is went against them because there are specific allegations, specific dates were there. This is item number
12 lawsuit.
You ask Mr. Goel,
Yes, he might be knowing.
Mr. A. Goel. He was the lawyer in that case.
In that case.
Yes. He was the lawyer for the respondent. Other side was, I think, Mr. D. Das. He was for the petitioner. Other was Diganta Das, I think. For the, oh no, D. Das, Lanet Senior Counsel was for the petitioner and he was for the respondent informant.
So in the meantime, I will file a short affidavit.
Whatever you want to do, you do, but we'll go on the merit, that's all. It is submitted, Mr. Ua Khandelan, G. Khandelia Learned Counsel, pressed for some time to address this court. Prayer is allowed. List this matter. 19 January 1st week or 2nd week. 8th of January.
Much obliged.
Yes. Yes.
But here in the case, out of love affairs, victim and petitioner were 11, but father of the victim has not supported that relation. And out of that, grasp, this case has been lost. But she may kindly have a look at the FIR, page 12.
Where is he now?
Regarding victim information, and my lord, so far as service report concerned, the informant is already died.
Informant.
Yes, well, father was the informant.
Okay. Any record with this? What happened to the investigation?
Charge sheet has been filed.
What is
showing
that?
absconder. But initially, the matter was registered under section 366A, but matter was charge sheeted under section 366, my lord.
This is a measure.
Yes, my lord. Whether she herself stated. And as per medical report also, my lord, stated that above 20 years.
Okay, we'll come back. We'll dictate this order. Nothing is there. She is a measure. In fact, during her examination, she stated that I went on my own. She is
I
a
don't think
measure.
anyone
The
should-
radiological report says 20 years. So, police therefore filed charge sheet under 366. So, on her statement, what is her 161 statement?
160 is not, we
You
have.
go through it. Go through it. Get to the statement 161. If 161 statement is there, what remains? Medical evidence there will cause this. Go through the 161 statement.
Problem.
Where is 161 is not there, na?
164 is.
Hard.
My lord, that CD part is not available, my lord. Only 164 and my lord, that is the medical report that is only available there.
What more is required?
Well, that is 164 is stated, my lord. See, when they married thereafter and the age is there is 20 years.
So, at best, there may be, if she said that he promised to marry when there, she induced her, that is fine. But there is no ingredients of either kidnapping or abduction.
Only one line she stated that mom mori jam boli koise hekane mo goisil.
That is out of love. In other
Out of
everywhere
love.
it is there. Why police file charge sheet in this case? Anyway, heard Mr. Swenso, learned counsel for the police. The present petition under section 482 of the Code of Criminal Procedure 1973 is filed for quashment of the proceeding of GR case number 1492/2009 pending for trial before the subdivisional judicial magistrate within bracket as Dibrugarh under section 366 IPC. IPC. The brief fact of the case is that one Pradeep Mura, isn't it, lost an affair before officer in charge Rasgor outpost, inter alia alleging that the accused Muhammad Amir Hussain, while was working under one contractor, Sisapon Das, at Rasgar Community Hospital, on 22/8/2009, kidnapped his elder daughter, who is aged about 16 years, and kept her for 6 days with him. Thereafter, he fled away, leaving behind his daughter at the house of his maternal house of in the house of his maternal uncle, and thereafter the contractor brought back her daughter. Accordingly, matter was forwarded accordingly. After registering a ZD entry, the FIR was forwarded to the officer in charge of Tingkhong Police Station. Resultantly, Tingkhong Police Station case number 116/2009 under section 366A IPC was registered. As the victim was already recovered, she was sent for her medical examination, and her medical investigation of sexual offense was done at the Forensic and State Medicine Department, Assam Medical College, Dibrugarh. Full stop. A copy of the aforesaid record, copy of the aforesaid medical investigation on sexual offense report is part of the record. The aforesaid report goes to show that the victim, the radiological report discloses that radiological examination was done for age determination, and as per the medical opinion, she is more than 20 years of age. In the format of medical examination, it was recorded that the victim disclosed before the doctor that she loves the accused, namely Amir Hussain of Dhubri, working as carpenter since 5 months. She went with him on 22/8/2009 to Dhubri at his house and got married and stayed for 5 days. On 28/8/2009, a man named Habibur came and brought her back to her parents' house and reported to the police station on the same day. She further, it was recorded by the by the doctor that she stated that they had enjoyed sexual intercourse for several times. She has changed her cloth, took bath, and has passed urine and stool after the last act. And she was brought to the forensic medicine department for medical examination. During the course of medical examination, the doctor recorded that in the medical report, the examining doctor recorded that there is no recorded, where is that final? Recorded that on physical, laboratory and radical examination, no evidence of recent sexual intercourse detected on her person, no evidence of recent violation marks detected on her private parts, and she is above 20 years of age. Full stop. The victim's statement was also recorded under section 164 CRPC, which is also part of the record. In her 164 statement, she stated before the magistrate that she is in love with the accused petitioner, accused since 7 months, while he was working as a laborer in Rajgarh. He expressed his love to her, and he He also proposed to marry her 11 days before, and they went to his native place. Such fact was not known to her family members. They stayed at Dhubri in his house and they got married. And she stayed with the accused for 4 days. Then thereafter, the contractor of Amir Hussain took back her. It was also stated that the Amir Hussain said that if she will not marry him, he will die. She further stated that after their marriage, they had physical relation. It was also stated that she was compelled to go with her as he forcefully requested. On the basis of aforesaid materials, that is her statement recorded under 164 and the medical evidence, though initially case was registered under section 366A IPC, the investigating officer filed charge sheet under section 366 IPC. Thus, 366 IPC as she was measured at that point of time. Now, in the backdrop of aforesaid facts, let this court consider whether this is a fit case within the fit case where this court should exercise its inherent power under section 482 CRPC. 482 CRPC. Mm, just a minute. Oh, just a minute. Law is by now well settled that where uncontroverted allegations made in FIR or complaint and the materials collected in support of same do not disclose commission of any offense and make out a case against an accused, this court can exercise its power under section 482 CRPC to quash such proceeding. In the aforesaid settled proposition of law, therefore, in the backdrop of the facts narrated herein above, and accepting the aforesaid material to be correct, now this court is to consider whether any offense under section 366 is made out to allow a prosecution against the present petitioner. Section 366, na? 366. Section 366. Section 366 IPC deals with kidnapping, abducting, or inducing an woman to compel her marriage, and prescribes the following. Quote 366. From the aforesaid, there is no hesitation in the mind of this court that the following ingredients prima facie ingredients shall be required to proceed a prosecution on the basis of the fact disclosed in the FIRs as complaint as well as material collected by the IO, i.e. 1. There is kidnapping or abducting of an woman. 2. Such kidnapping or abducting must be with intent that she may be compelled or knowing it to be likely that she will be compelled to marry any person against her will. Then or in order that she may be forced or seduced to illicit intercourse, or knowing it to be likely that she will be forced or seduced to illicit intercourse, and or by means of criminal intimidation or otherwise by inducing any woman to go from any place with intent that she may be, or knowing that she will be forced or seduced to illicit intercourse. Okay. In the aforesaid backdrop, therefore, what will be required is either abduction or kidnapping. Abduction is defined under section 362 and mandates that whoever by force compels or by any deceitful means induces any person to go from any place is said to be abduct that person. Thus, there must be a forceful compulsion or inducement by deceitful means. And the object of such compulsion or inducement is must be is going going of a person from one place to another. Now, the deceitful meaning is also a necessary ingredients which include misleading statement or misleading statement. Full stop. It is by now well settled that to rope into a person under prosecution under section 366 IPC, mere abduction of a woman is not enough. What more is required is that the purpose of abduction is as mentioned and as recorded by this court in the foregoing paragraph in section 366 IPC. Now, coming to the case in hand, just a minute. Coming to the case in hand, the material so far collected, including the statement of the victim under 364, 164 CRPC, the medical report are accepted and treated to be correct. What is discernible is that the victim was a major. She went with the accused out of love. They got married and they had sexual intercourse, and she was taken from that place. She came back from the place of the accused by some other person and not by her. She was consistent with death, though her statement before the medical officer may not have any relevance for the purpose of trial. However, it is on record that she stated in a similar nature before the medical officer. Therefore, in the totality of the matter, this court is of the view that the essential conditions for application of section 366 IPC, that there is a kidnapping or abduction with an intention to compel her, or knowing it to be likely that she will be compelled to marry a person against her will, or will be forced or seduced to illicit intercourse, is not available at all, inasmuch as it is the case of the victim that she had a love affair, and she has nowhere stated that the majlis were under any compulsion. She had also not stated anything that she had physical relation with the victim, either under any compulsion or inducement. Rather, she stated that after the marriage, they had physical relation. Therefore, in the aforesaid backdrop, this court do not find the ingredients of either of section 362, 360R or even 366 IPC. And therefore, in the backdrop of the statement of the victim herself, the prosecution, if allowed, shall result in miscarriage of justice. Accordingly, the present petition stands allowed by setting a certain crossing, so and so, so and so, so. Else, the LCR be returned back.
Nice.
Scan copies are there. There is no interim order. Find out what happened to this case. Not there. Scan copies of the diary was called for. It was in FIR. Not received. So thing is that there is no stay order. FIR was registered by All Women Police Station. What is the status? Let us know. If already search sheet is filed, nobody is appeared. None appears on 24/11. None appears on 19. Yes. The present application is filed for quashment of FIR registered in FIR registered as All Women Police Station case number 115/2018 under section 498A IPC, read with section 4 of the Dowry Prohibition Act. While issuing notice of motion, this court under its order dated 16/9/2009 call for the case scan copy of the case diary of the above noted case. Stop. The scan copy is not available. It is also a fact that no interim order was passed by this court stalling the investigation. In view of the aforesaid, Mr. Swenso, learned additional public prosecutor, shall obtain the present status of investigation of the Swenso All Women Police Station case number 115/2018. List this matter on Tuesday. Have a telephone call, bring it. If no, nothing, search it is file, closure. Yes, next. None appears for the petitioner on call. Though Mr. Swencho is present. Sharma. By filing this petition under section 482 CRPC, the petitioner has challenged the FIR dated 13/6/2019, registered as Bhorolumukh PS case number 306/2019 under section 420/406 IPC. The FIR is quoted herein below. Page 11. From the FIR, what is the following facts are discernible? From the FIR and the statement therein, from the FIR and from the statement therein, comma, if everything is accepted to be correct, discloses the following facts, 1, 2, 3. The informant paid an amount of rupees 35 lakhs to Messrs. Arihant Constructions by RTGS on 27/10/2015. Two, in spite of reminder, the accused has not returned the said amount till date. Accordingly, said checks were deposited. However, both checks were returned by the bank. In the aforesaid backdrop, the informant is facing financial crisis for his treatment and crisis for his treatment. And accordingly, it was requested to the police investigating officer for realization of the principal and interest amount. Full stop. On the basis of such aforesaid, the police station case as recorded herein above recorded, though such investigation was stayed by this court under its order dated 21/10/2019. This court, after perusal of the material available on record and the case diary, it is seen that the entire dispute is non-payment of alleged legally enforceable due and dishonor of sec. In view of the aforesaid, at best, this can be an offense under section 138 of the Negotiable Instrument Act and cannot be termed, and no ingredients of whatsoever under section 420 or 406, no material whatsoever as regards commission of offense under section 420 or 406 is available. Accordingly, the so and so is set aside and quashed. What is the police also seek?
Roger, I'm sorry, in item number 12, I forgot to mention that the interim order may continue.
Interim order may continue. Item number 12, what happened? Okay, interim order pass. Let's welcome. Who is it? Yes. Mr. Das, I think you are here for hearing or what?
After a long time, you know.
After a long time.
Lordship, kindly may allow for timing, Lordship, my senior is.
What is the case about? Tell us.
Lordship,
Who is your senior?
MH Ahmed, Lordship.
Okay, till NH Ahmed comes, let us understand what is what.
That's true, what? That's true. Lordship, the case is that it's the revision petition, Lordship. The petitioners preferred an appeal before the learned session.
What is the initial conviction?
Initial conviction was, Lordship, 5 years, Lordship.
Then,
Then it
under
was-
section?
T25.
325,
Lordship.
325, and subsequently
It was reduced to 2 years, Lordship.
2 years under 325 or 323 or some. What is this?
Sessions tribal case.
Sessions tribal, not appellate. What you say? The judgment says it's a session judgment.
Session resistance session judge. Lordship, initially it was convicted under section 307. Kindly may allow for timing.
We do not expect a young lawyer to come and stand like this. Your senior may not be there. Therefore, we'll do our job on own.
Trial was held by assistant session judge.
That's right.
Appeal was filed
That's
before
right.
the session judge.
That's it. You take out the evidence of PW1, PW2 and the doctor's evidence. Mr. Das, go through it. We'll take after some time. And CW2, because two injured witnesses were not examined by the what I could gather here, I have also not gone through right now. One injured witness was not even listed as witness. Okay, so court on its own call, I think so. Apparently, what seen.
As
And
court
as court witness, that was relied on.
No.
So that was one of the ground that whether that is valid or not. This is one of the ground taken in the appeal, and that was discarded.
Court has the power, my lord.
Yes. What you say, Mr. You are safe today. Good that I have seen the names. Which place? Which place? Borpeta, but names are familiar. Which place? Which place? Please see. Please see. Hati, Kusi. Where this incident happened? Oh no, this is not. No, no. Yes, I can take up this. This is something different. This is not.
Gonokpur.
Tarabari. Not proper Borpeta. This Senga and all, not. PW3 also you look into.
Mile.
PW1, PW2, PW3. PW3 independent witnesses are there, PW2, PW3, I think, and we injured are there and medical report. That's all. That too. Go through that. I think that too.
It was concurrent finding.
Concurrent finding.
And favorably reduced his sentence and what more interference.
What do you do? At 2. What do you do at 2? Okay. Next.
My lord, in better because Abha Bhattacharya is leading the
Uh-huh.
Abha Bhattacharya is
Yes.
bedridden due to fracture of the leg. Another thing, the brief is misplaced, your lordship. The matter may kindly be fixed for your lords.
That is not at all possible. 2012.
Yes, lordship.
10 years gone when? 2022. I'm prepared at 2.
If it's not.
Okay. Well,
Date.
no dates. Okay, let's look at 2. We'll see. If we can complete the other method. Yes, next. Yes.
Division is
Against?
against the appellate order passed by the learned Commission of Israeli.
What was the issue here?
Appellant's petition dictated by the learned magistrate,
Hmm.
Vishwanath Saili,
Under section?
under section 320-24, 447, 320-34, by awarding imprisonment of 2.5 years and 2 years in 324
Hmm.
and 2 months in 447, my lord. And against that order, appeal was before the additional session judge. Additional session judge set aside the conviction and 24,
Hmm.
but upheld the conviction under section 447 and 323 by awarding imprisonment of 2 months only each.
Hmm.
Against that order, we have come to revisions. Actually, it is the incidence of.
What is the wrong, perversity, illegality, patent error?
This is under section 2006, my lord.
Hmm.
Hence took place 2000. What happened? The one Rajiv Boro,
No, facts will go later on. Facts will go later on. Because we are in a proceeding under revisional 482 or 327. Two courts concurrently convicted you, maybe lesser, better. Now, before going into details, you will have to first satisfy us that primarily these are the patent illegality, patent error. Then, if necessary, this is the perversity. Then even we can reappreciate the evidence, no problem on that. But if you start with these are the facts, we are not going to.
It is against conviction, my lord.
That we understand.
Your lordship will have to go to the evidence.
No. Where is the law?
Against the conviction, when there is a conviction, the evidence can be reappraised.
No, until and unless you can satisfy that there is perversity on this point.
Rajiv Behera.
Hmm.
Rajiv Behera, he has stated.
So you want to say this is a kind of a second appeal? We want to say that this is a second appeal. Where we'll have to even second appeal in civil not allowed.
Then evidence cannot be, but when the revision is against the conviction, if the conviction is.
When revision is against the conviction, we will even reappreciate this evidence. No problem on that. We can reverse this, no problem on it. But only thing is that we will not start with what was FIR, what was not. First, you will have to highlight that these are you will have to give a chance to open the book. That these are the points where perversity was committed. We will not start what happened in 1947, then what evidence, we will not go to that. That is as simple as that.
One by one.
Yes.
Just consists of two parts, my lord.
Okay.
According to FIR.
Hmm.
Because the Rajiv Behera,
Hmm.
he went to shop to bring the kerosene.
Hmm.
Then Mohidhar Rajbangshi,
Hmm.
he has restrained him on the way and assaulted him with a meat, my lord, backside of the meat. Then he demanded rupees 20. He refused to give it. Then he assaulted. Then he ran away to his house, my lord. Then he ran away to his house. Thereafter, this Mohidhar Rajbangshi, taking other accused along with it, went to his house and assaulted all these members, my lord. But here, my lord, Rajiv Behera is the main accused from which the prosecution started. But that Rajiv Behera was not examined, my lord.
You say that. This is the issue. You say that the vital person who is the eyewitness or who is the accused or who is so and so, not even examination, so it's resulted in perversity. That can be a ground to reappreciate. If you start the evidence, no, this is the not, we will not go. You will have to first pinpoint that these are the error or patent illegality committed. This is perverse. Then we'll start and we'll go to every evidence.
On examination of the Rajiv Behera, who was assaulted first, is this a fatal to the prosecution
So
case?
one of the witness is not examined. Injured with it.
Because he was the injured, my lord.
That's why injured, one of the injured victim is not examined. Therefore, this is fatal. That can be one ground. This is an error apparent. We'll see whether this is fatal or not.
Secondly, my lord, according to the injured, the Mohidhar Rajbangshi, taking with other accused with them, went to the house of one Bipul Behera and assaulted all these members. These are the examiners PW1, PW2, PW3, PW4, and PW7. They were injured, they were assaulted. There was no independent witness except this family member assault, no independent.
So you want to say, except the injured witness's testimony, there is no independent witness. This is one. My answer to it is, if injured witnesses standard is in a higher pedestal, no eyewitness is required, it is corroborated by the medical evidence. So therefore will not look into. If you say that there is a perversity between the injury stated to be inflicted and medical report, then of course we'll see. But we cannot do a revision the manner you are proposing to do. That we cannot.
Minute details of.
No, we cannot. That, even if we go to the each and evidence, we can read it. But we are not supposed to until and unless you show us something. So this is second part. Non-examination of eyewitness. That is discarded. That cannot be a ground to the.
No independent witnesses examined.
Not necessary.
Two independent witnesses examined, but they were not the eyewitness. 5 and 6
Okay.
independent witness, but they were
They are
not
not
the
eyewitness. Okay, fine.
They have not seen the occurrence.
You tell us why, what wrong has been committed by the board court while relying on injured witnesses and coming to the
Not very full injured because Rajiv Behera, he was the first injured witness. He was not examined. That is the fatal to the prosecution case. Because
Why?
that part, even that part, that he was restrained on the way by the Mohidor Rajbangshi and assaulted him. This is not stated in the FIR also, that person. You are also kindly allow me to read out the
who was not assaulted?
Rajiv Behera. Rajiv Behera assaulted by Mohidor,
Hmm.
Mohidor Rajbangshi. On the way, when Rajiv Behera have gone to shop to
Was
bring
not
the-
even alleged.
being the kerosene.
Hmm.
He was assaulted there. Thereafter he ran away to his house.
That Behera.
Behera.
So that is not alleged in the affair.
This is not alleged in the
Now how can you say that he is an injured witness?
No, it has come in the evidence. Peter one has stated in his evidence that my brother Rajiv Behera was wanted to assault by the
Now how this will be fatal so far relating to other witnesses? And
it is the prosecution criminal case. The prosecution will have to prove the beyond all reasonable doubts, my lord. The proof, it may be in the trial court, it may be in the appellate court or in the revision. Beyond all
no, don't say revision.
Beyond-
Revision is we are not bound
beyond
to.
all reasonable doubt case is to be proved, my lord. Here the beyond all reasonable doubt is not proved because one part of the incident has not been stated in the FIR. And that person who was assaulted first, from whose the prosecution story start was not examined, my lord. No independent witnesses supported their case. Third vital fact in a criminal case, my lord, it will establish the case is not proved beyond all reasonable doubt. Non-examination of the Rajiv Behera has established that there is a doubtful in the prosecution case. Even that person has not been stated in the FIR also. At the beginning of
So
the
if
case.
something is not stated in the FIR, can you say it to be a prosecution case?
That is not
Prosecution case starts with what? That this is the case of the prosecution in the FIR.
doubtful. The doubt has come why it was not stated in the FIR, why he was not examined. Rajiv Behera, why he was the first
Okay,
one
doubt is created. That doubt, how will you benefited by that doubt?
When there is a doubt in the prosecution case, benefited go to the defense accused.
Doubt, what doubt? Doubt means cannot be a doubt as a whole. This is a doubt. Doubt means what? This is a specific that I was beaten up, I got injured. There is a doubt whether I was beaten, he was beaten up or not. That can be a doubt.
The story is false, my lord. If he is beaten by the Mohidor Rajbangshi, then he would have been examined by the prosecution, my lord. And he
That
was not
doubt
examined.
means, there
And
must
the-
be possibility of
Two
second.
things.
That is
Two views.
That is not maybe it is.
Whether he was present, whether he was not there, if a doubt is created. Many things are there. Suppose there is a sans witness. He is saying something. Some explanation is required. How, why, and under what circumstances he was there. He may be projected. If two witnesses, one is not examined, two witnesses is there. Sometimes it may be fatal or a witness is not named. Suppose one witness says he is here and he is here. One says only he is here. sometimes it can also be created out whether the main witness was present or not. These situations are there, but here is a case prosecution according to you will hear you at 2, not 2 after the other matter. Prosecution case is that so and so was beaten up, so and so was, there is no mention of presence of Mr. Das. But during evidence, some witnesses says that Mr. Das was also there by the injured witness. Now, presence of Das will create any doubt that other accused were not even beaten up. If injuries are stated to be remain unrebutted or unshaken, and medical evidence corroborates it, what more is required?
The evidence, apart from the assault of the Binod Behera, therefore net portion will come. When he ran away and informed.
Okay.
It
It is one.
So he will have to state that.
Yes, we'll hear you. We'll hear you.
My submission was beyond reasonable doubt. Beyond reasonable doubt cases to be proved. Maybe the revision, no matter. But it is a conviction again.
No.
Conviction also.
The
evidence can be
fundamental
made.
principle in a criminal prosecution is a man must be proved guilty beyond all reasonable doubt. Is not it?
Yes.
That all beyond reasonable doubt comes from an evidence. The prosecution evidence.
So many.
I do not think I will have to explain to all this. Mr. Sharma, please listen to us. With my limited knowledge and with your huge experience,
I am not going to say that I am so much.
I am telling you what my limited understanding is. Prosecution launches a case on the basis of an FIR. FIR is not a gospel truth. Or not the encyclopedia. Listen,
Right.
not the encyclopedia.
Yes, correct.
On the basis of the FIR, police starts investigation, collects material, evidence. Now, they investigating prosecution is left to prove beyond reasonable doubt through these witnesses that this allegation or charges frame under section so and so is established beyond reasonable doubt. Any doubt will give you an acquittal. Okay. Now, 2 of the courts found it that there is materials which are beyond any reasonable doubt. They can come to a conclusion you have committed offenses under so on and so forth.
I have not
Please,
appreciated the evidence
Mr.
properly.
Sharma, listen. Now, you will have to show us that this determination is perverse, or there is a patent illegality or defect of law or error. We are not here to reappreciate evidence. We are not here to reappreciate evidence. Yes, we'll again go to the evidence if you can prima facie show that there is material, there is perversity. Of course, we are open. We will not allow any person to be convicted without beyond reasonable doubt. But the proposal you are giving that we will have to again reappreciate evidence, this is not. Take note of the judgment 2015 8 SCC 774 and address us.
May be allowed to read out the evidence. So what is the contradiction?
No,
What is the-
I will not allow.
If
You will have to say that these are the points so and so said, so and so is.
Then my lord, my under submission, it is the case of 2006, my lord,
Ah.
19 years over. The conviction is under section 447, 20T, where the imprisonment is not must, or justice can be done by imposing fine only. Under
If
section
there is a prescription and you can satisfy that, we will definitely do it. We are doing it. If you can say that this is permissible, that this offense sentence is either imprisonment or fine, then of course, if the materials are there and the considerations can be taken, we'll take note of this. Think over it. At 2. Chalo.
imprisonment or fine, my lord. The imprisonment or fine, my lord, not must.
We'll see that. Yes, so Mr. Talukdar, tell us.
24 and 25, but 3 matters are already there. See, it's a long matter, CBI. That is also.
Okay, this is by CBI.
He is there.
But CBI, sorry to say, you take so much of evidence, so much of
every case.
evidence, so much of exhibits, but what is required is not there. Sorry to say.
I also was in defense.
Huh?
I was in defense. I know that, Lordship.
No, in this case, I do not know, but some other cases, I have seen
definitely. All the
45,
witnesses are coming.
46 witnesses
Mm.
from the travel agent to everybody is examined. But how the signature is forced, it is not established. What is the meaning of establishing who went where, when letter was sent, it was not returned? Fundamental is that I allege you to have committed 468, 420. You know why I am saying all this.
Our purpose is there. Things will not the accused person get terribly scammed.
That,
They are
No, that part is
suddenly
not.
going to.
Mm.
because I did not have that much of wholesale experience or like in CBI cases, whatever I did is either the help of these people or somebody. But the way now I am dealing with these CBI cases and everybody is tense allowed. In your case, normal. In his case, we have made an observation. That and it is we have responsibility of NHIDCL. In your case, Mr. BC Das's case, while parting with the record, it is made clear that no compensation can be paid to the petitioner organization, but to the individual landowners, depending on the facts of their individual case. That's all. This also we'll correct it right now. Maybe tomorrow or day after Monday, we'll get it uploaded. Not today. But I have some information that tomorrow this floor will have no electricity.
Oh.
Isn't that it? So therefore, whether we'll be able to upload or not tomorrow, it is difficult, though it's a working day.
Right now, we are in a position to just.
Not now. There's some cease overwriting and all. Because till last moment there are corrections. Okay. Allowed. We have held that you will be entitled for compensation under 2013 Act. In your case, whatever is paid adjusted and all other benefit, they will have to
That vital pair, but that the direction to the DC to proceed the matter expeditiously so that.
No, that we have given within a period. Within a period. We have mentioned a specific period.
Yes.
Within a period of we have but given a little more time because NHIDCL info 6 months.
That will not. That part will. Okay.
Yes, Mr. Doctor, allowed. But one difficulty still I am facing. That's why I'm not signing right. See, apparently I hold that this cannot be done or cannot be taken. What will happen to the other person who has not come before us? That is where I am a little bit. See, here absolutely cannot be in view of whatever you have argued. So the second complaint case cannot be. Maybe against you, maybe against them, but they are not before us. But at the same time, we have given her a liberty. We have said, I think they have filed already. We have said that this court cannot be oblivious to the right of the victim inasmuch as there is no provision under section 321 CRPC to ascertain the right of the victim. In the considered opinion of this court, the victim shall always have a right not only to participate in a criminal prosecution, but to object withdrawal of a prosecution under section 321 CRPC. Therefore, have brought in the Jagjit Singh's proposition. Therefore, an aggrieved victim can very well approach the superior court if aggrieved by withdrawal of a prosecution by state, maybe under section 482 or in a given case under provision of article 226/227 of the Constitution of India. However, there is a positive sense in this regard by virtue of enactment of section 360 BNSS 2023, which prohibits withdrawal of prosecution by state without giving notice to victim. But what will happen to the other two? They are not before us. What will happen. They will come and say this, show this judgment and get relief. This is what we have.
I'm updated.
Okay, so you are at liberty now to proceed. Mr. Sharma, please come forward. We'll take up your matter. Give a date next week or thereafter. You give a date next week or thereafter, as per your convenience, and think over of possibility. And Mr. Das also suffered a lot converting into the fine.
Imposing punishment is a judicial.
No, we understand. That's why we are explaining. We are not passing this order. You just think over that proposition. Mr. Das, you also.
Total punishment.
2 months.
1 year.
3 months.
And probation of offenders that
Then probation of we have given in probation of offenders, or you may convert into only fine. Only fine. That will be, I think, better proposition. Taking note of. So we are not dictating this order today. Our first, we'll try to have completed all these 6 judgments today. So you give a date. Yes, ask your senior. You.
Wednesday.
It will take 10 minutes. 5 minutes to dictate. Fourth of this.
21, I have almost examined the evidence on record.
This is item 20.
21.
Yes.
In this case, my lord, initially, my lord, 5 years, RI for 5 years was imposed lordship. On appeal lordship, it was reduced to 2 years, my lord, under section 325.
Yes.
IPC lordship. Now, the witnesses lordship,
PW1,
PW5, and 7 lordship, and CWs 1, 2, and 2 lordship. Those are, my lord, vital lordship. PW1 is the, my lord, mother of the, my lord, victim lordship, injured. And
all are interested.
My lord, yes, of course, lordship.
That is your argument. All are interested.
Now,
forget about others. What the injured witnesses says.
Injured witnesses says the first of lordship, the accused are pagal, met. Specific statement, accused are met.
So therefore, they should get a benefit of
that is one aspect.
insanity.
84.
Okay, very good argument.
How that can,
What do you mean by
that is a
that?
plea. That is your plea. You have to take that plea.
Take that, please.
My lord. Now, as specific answer, statement lordship. Now, my lord, his statement lordship, he was examined by Dr. Aibur Rahman, Sangha, PhD. But doctor examined Nurul Islam.
Any explanation?
No.
Why he has that? He was a hospital, he was the doctor, he knows the signature, he was not examined, he was examined by.
Nothing. Nurul Islam stated he himself examined the injured, he issued certificate.
Okay, that is Nurul Islam.
Nurul Islam.
Who proved this certificate?
Nurul Islam lordship, himself examined as PW5.
I am not getting it. Who examined the injured?
He examined.
Actually, 2 doctors examined.
Okay.
2 doctors examined. He was subsequently referred to GMC.
That we have seen.
Yes. So PW6, evidence of PW6 is important.
That
So
is
for-
who examined in the medical.
In the medical
medical
report,
college.
got operated it on.
Yes,
lot-
how they were brought
yes,
in.
What injury he has given details
Okay.
regarding injury. Not a
Okay.
fracture, both leg, milord. And as per evidence of prosecution witnesses, he has become handicapped. Thereafter, he cannot do any work. And so far, milord, PW2, PW3, and PW4.
This is a criminal revision petition.
Yes,
Okay,
Lord.
we are giving you some breathing space.
Limited scope is there, lordship.
So if you can see This is a case under 325. 325. Now, in case of a 325, what is the vital evidence? Is the injured evidence. Okay. And whether it has been corroborated by medical evidence.
That is why, Lordship.
Listen. That is why. Are you arguing today? It's a different. I am asking you to highlight all this one. So, one is a injured witness. It is difficult to say a person is 302 because the dead person is not before the court. Understand? But in a case of 325 or 323, the witness is injured himself. And law in India is well settled that an injured testimony is put in a higher pedestal. Okay? So if he is not having any material contradiction to create doubt or his intention that it is a false case, number one. Number two, if that is not there, to how far medical evidence corroborates his injury. Okay, he says, I was hit in my head was totally, I was bleeding. And the doctor says he was brought to my clinic or my hospital. Apparently there is no injury. This is the injury report. Then it will be a not corroborated. So therefore, these two vital points, and in a revision, we will only consider that some irrelevant materials are taken note of in convicting you, or material evidences are ignored, or that on the basis of this evidence, this material, the evidence of witness and the doctor and all, a reasonable person could not have concluded in the manner that has been done by the trial court. This is your scope. That's all. Yes, Mr. Das, you also. If that is everything is, if there is no material contradiction, the injured witness cannot be disbelieved. They are supported by corroboration. Methods they are in a revision. Nothing more, nothing less. Yes.
For that purpose, kindly CW1 injured.
You want to argue today? Okay, fine.
Lordship, then my lord, other day.
No.
Fixed, Lord.
I will not. I thought that I am highlighting the issues where we'll have to argue. If you are ready, we are ready.
The periphery of arguments.
I am just saying periphery of your argument. You highlight and show us. It will take 5 minutes me to dictate this order. If you show that yes, this is the budget. On this basis, it could not have been done. I am giving you the outline. If you are ready, I am ready.
It may be fixed other day, Lordship.
I have gone through the evidence on record. In revision mode, there is hardly any scope for Millard because he has. Yes, one thing is that surprisingly, for reasons not known to me, Millard, the CW1 and CW2. CW2 is the wife of victim. They were not.
She was the eyewitness. She was not even investigating. Listed as a witness.
Yes,
but there is you cannot find fault on her.
Otherwise, the court has done the right job.
Even if we discard their evidence,
my lord,
other eyewitnesses are there, and there are 3 eyewitnesses.
Not this PW, as your lordship has stated me, what I could find, PW 2, 3, and 4, their evidence is res judicata evidence.
Okay, not eyewitness.
Not eyewitness.
Immediately they came.
Yes, they were reported by the
But
PW1.
did they say saw this man in an injured condition?
In injured condition, immediately they come.
So they may not be the witness of the actual incident,
inflicting injury,
but their evidence will be a corroborative evidence to establish the fact that this fact happened in this area.
Exactly.
This evidence may not be for the purpose that this person hit him, but to establish that a person was found in an injured condition. That evidence may not support that so has beaten him up. That is, you cannot believe.
Attribution may not be there.
May not be there.
They were reported
but in the chain of facts that he says that I was beaten in this place.
Yes.
This is my injury. Medical report corroborates. Now, other witnesses we have not seen, they say that yes, we got him in injured condition, took him to hospital.
They heard hue and cry. They are neighbor. They heard hue and cry, and then immediately they came.
This is the spot. This is the issue. And if you are ready, we can go through this evidence and complete this today. Already only 2:30. That is what Mr. in earlier cases of Sharma I want
That
to
is
say.
also my lord.
And that's why these matters are not being completed.
Yes, exactly.
We cannot go
And
each and
increasing the volume of pendency here.
we cannot read each
unnecessary.
and every evidence. We'll read it, provided you can show us that this is the. Huh?
Not an appeal, Lordship.
So proceed or 2012.
And in that next
Before
week,
that, what was their age at that point of time?
yes, probably they are above 50. Lordship.
At that point of time.
No, not,
Oh, no, I'm
at
trying
that
to-
point, they were young, Lordship.
Okay, just confirm it that they are
2003.
still in this world.
2003, Lordship.
Then
40 years at that time.
at that point of time, 40.
One is 40 years.
Now what is
Virendra was 40
12,
years.
2012?
Huh?
20 years.
তোর নাম কি?
তো এটা হল এই নিপেন
Dipendra Joshi.
he was Nipendranath, Viren Das.
Viren Das was
They were their
Viren Das
brothers,
was 40 years.
brothers, and Nipen was young.
Forest Das was 50 years.
They have crossed 60, 2 and 3 crossed 60.
2012. Then 2012 you add. No,
20,
incident
20
is 2012 is appeal incident.
Final incident 2000, yes, Lordship. No, Lordship, 2003.
Then
FIR was in 2003, Lordship.
so along with your point of argument, you verify other aspects also.
FIR 2027.
Do you have any
29.
link? Do you have any link with your client?
Many days, Lordship, no communication.
কষ্ট হয়ে নিয়ে যাবো নহলে
That's that's
This is my whether they will communicate or not. My lord,
yes. And what is the next case?
oblige, Lordship.
Keep it at 2012. Now it will not take much time. Revision, give this within. I'm giving lawyers a chance to argue
My lord,
within this perimeter. If he is ready, I can proceed. I have no problem. I'll see everything, but it is not that we will have to read each and every evidence. If you can highlight that this witness is by it is not supported. Of course, we'll see that injured victims' evidence, doctors, and independent witness. 16th of December. Yes, next. No, this somebody said somebody is ill. When can you do it?
The brief is also not on my.
Oh, don't say all this. Then we'll proceed today itself.
Lordship.
No, January 1st week, no scope. That I am telling you.
Lordship in December.
In December. We are giving a chance on the ground of held ground of a lawyer. But we cannot wait a 2012 matter. We'll engage a amicus and we'll proceed. That's all.
second week of
December, not 19th.
second week of December.
Second week of December. Mostly all these are revision petitions, is not my master, not a appeal.
14, but 12 to over. 12.
12th of December. Yes, Sharma and Ahmed, anything? Nothing. Taking rest. Okay. Oh. Understand the lawyer's mood and measures, or who are you? Yes, what is this? Yes, Sharma. Mr. Das, here is a case, it is a jail appeal, but relating to POXO, something like that. Two cases are there, na? Two cases. They are inside. And there was a direction on 12/2/2024 by coordinate bench saying that issuance of notice to the father of the victim, PW3, be served through officer in charge of Soraipung police station through your office. Okay. Then on 1911, P. Borthakur, additional public prosecutor, short time. This is my order. Saying that he will obtain instruction by 27/11. Now, when the 27/11 matter was listed, Mr. B. Sharma says that give me 2 days time. They've given 2 days time. Today is again listed.
Instruction has not come.
Now, then in the morning, he said that I will be back with the instruction.
My colleague has gone to
Okay, if that be so, if it is served, we'll ask somebody to assist, represent this accused. If served and has not come, then also we will ask somebody, but we will have to record it.
Yes, yes.
And this is a matter of 2019. Of course, we'll fix this matter. Already 6 years is over. I think around 10 years. Two matters, na? Jail. So I have given an instruction that at least criminal appeal those who are inside, because most of the criminal appeals pertaining to single bench, everybody is outside. Those who can afford a lawyer. But these are the jail appeals. So we'll give, though if it is 19, we'll give a first preference.
Conviction under Milord?
POXO, I think. POXO.
No, since these are Milord jail appeals, we do not have any papers. No.
The paper books are there.
Paper book, it is
No,
not-
if you are not having, in one case paper book is there, and you can go through the record, and in fact,
Hello, we can finish it if the paper book is there. I'll make a search in the. But the thing is that if the appellant is not represented, how?
no, appellant is not jail. Appellant is represent. We have appointed amicus.
Amicus is there.
Amicus is there, but
Whether
that is not the issue. Issue is of the victim.
Acha, victim.
POXO. Otherwise, we are proceeding.
Service of notice.
Service of notice. That is why on last 3 occasions, times were granted to the learned public prosecutor. That instruction we need. If it is served, then also not appearing, then also we are engaging somebody. If not served, then also, then we'll proceed.
Whether Milord, it is usual notice or Milord registered post, Milord?
No, through that, under that notification, through
Our office.
through your office. Through the police station. What
Then
is
we
that?
can, we can have instruction, Milord.
That's why. It is one, in one case, it is through notification 17. In terms of notification 17, 15/3/2024. So my idea was to appoint somebody for
Yes,
the victim today and finish it up this matter later part. Here is also what is the evidence that we'll have to see. That's of the victim.
But thing is that if notice is not served or the person is not found, in that case again.
Then therefore that what I want to know. Then what I am doing is I will appoint a counsel for the victim also. A legal aid counsel will appoint. At least he is not go unrepresented in a POXO case. Therefore,
I will intimate mostly, whatever instruction comes, then you also will be able to pass.
Okay, then these two methods.
My colleague has gone to take the instruction.
Okay. Some pending methods are there, all these disposals.
I don't know, some cases have been
Yes, Ahmed.
disposed of today. And in other courts, hearing
He
matters.
was, I think, Mr. H.R.A. Chaudhary Junior, he also used to assist you. There is a issue crept in. Complaint. What is the meaning of a complaint? More particularly when it is an offense under section 211. What is a complaint? 2D oral or by written. A magistrate passes an order saying that I have gone through 164, I have gone through this, and in my opinion, it is an offense under 211. So therefore, he has given the reason why he thinks it to be. And therefore, send this order to the learned CJM to be treated as a complaint to proceed under 211. Now, first contention is that this is not a complaint. So I said, why not? Complaint says it is either oral or written.
That is definition of
2D.
Yes.
2D. If 2D is, he has written it. And he has not taken any legal action against that person. He has expressed his opinion saying that this is what is done according to me, 211. He has not taken cognizance. It was sent to the
Actually,
magistrate.
he has become complainant.
Complainant. And he said it is to be treated as a complaint under section 20.
It has to be seen that whether he has passed an order or the language used by the informant who disclosed the incident.
So he has recorded that in the FIR it was seen 164 statement, 161 he has said this. Whether that it will be a different issue, whether this is an offense under 211. We have not gone to that because his whole case is that an FIR was lodged alleging rape. Okay. During 161, she said that I have wrongly, falsely implicated. 164 statement was recorded. She said I have falsely, no rape was there, I have falsely implicated. And accordingly, final report was submitted. While taking final report, it came to the magistrate that this is an offense under 200. Whether this is an offense under 211, this statement is 164 is there before a magistrate.
That is there.
That is there. So whether it is an offense, it will.
This was that whether complaint
So his first argument is that it is to be formed because he relied on my judgment that some Neput Redum. You were also there. So I said, okay, that is fine. But in that case, FIR was directed to be lodged. Here he says, treat my what I have was found, treat it to be a complaint. Then
I will be on the next day, Lord. I will assist him.
No, well, once final report has been submitted by, it is not a discussion of the magistrate. He can apply.
No, he has accepted the final report.
Accepted.
Final report is accepted, but according to
But
him,
without issuing notice, the
no, notice was issued. Final report was
that part is
accepted
done.
because both parties are agreed.
Oh,
The lady alleges rape against you. During 161 statement, she says that I was not raped. I have not only said I was not raped or by misunderstanding. She specifically said I have lost a false case. In 164, she said that I have lost a false case. So therefore, while accepting that, magistrate thought it, what is this unnecessary? You have filed this and you have stated before the magistrate and you have lodged a false case. So whether lodging a false, because she has said truth before the magistrate. She has not misled the magistrate. That can be an argument whether it will be 211 or not.
They are in petition also.
Is it there? But his first argument was that it is to be under complaint.
Now I got the point.
So his order, he still says that it is to be treated as complaint. So if that first point gone, then other will come. Whether this is in fact the wrong statement, because she may be prosecuted for malicious prosecution. 211 is not a malicious prosecution. 211 is stating false fact before adjudicating machinery, maybe high court, maybe. Now she has not said any false thing against any court. She said, yes, I have lodged a false case. Whether this will come under 211, that can be a different.
That too, the
Perhaps 195 bar, that whether that will come or not.
No, that is what 195 bars, that there cannot be any prosecution without a complaint. That is their argument, that this cannot be treated as complaint. So I put a question, when the magistrate says it is to be treated as complaint, and definition of complaint says either oral or written. So this is a complaint. That otherwise whether 211 or not, that will.
And by virtue of that, the magistrate himself has become complainant.
He has complainant. So the what CJM did is he said that it is a case is made out. Now next question will be whether 211 will be attracted, because she has not stated false thing before the court apparently.
Yes.
He has said the truth before the IO and the court. But she lost the false affair. That may be an offense of malicious prosecution, which is to be lost by the victim. Or maybe police, after filing final report, there is a provision to prosecute. What is that provision? There is a provision that for this wrong case, a fresh prosecution be initiated against the.
Yes, that
there is a provision. With my limited knowledge.
The target also that is mentioned.
That is mentioned. Yes.
211 will hardly, perhaps hardly come. my lord, 200.
That is it. 211 is when wrong, false statement is given before
Before the court.
court.
Or
Here
false
she has
evidence is
stated the correct facts before the court.
In fact, there was, so far I remember, also there another case was there against her husband, against 376 also. So she filed this case to save her husband. Probably that was there.
One is Hatsingimari.
Yes.
My lord, I made a query in this regard, my lord.
Ah.
Mr. Sharma also on earlier date, he made a
Ah.
communication with the office, my lord.
Ah.
And they have sent, my lord, but the thing is that the phone numbers of the OC concerned, my lord, Soraipung and my lord Hatsingimari, my lord. And both the numbers is not, my lord, active because.
Don't say that live streaming is going on. Then it will be very bad on Assam police, the smart police.
My
That
lord,
OC's phone number is not working.
my lord, maybe some changes are there. So my lord, maybe
They
given a
must
one day
notify
more
at
time,
least
my
the High Court's public prosecutor office that my phone number is sent. It will reflect very bad. You do something, whatever we do.
My lord, that will be done, my lord.
You
My
will
lord,
do it. Will not record anything.
Yes, my lord.
On the prayer of the learned additional public prosecutor, last adjournment is granted.
My lord.
And matter be listed on Thursday, next Thursday.
My lord.
Next Thursday,
My lord.
Swencho.
My lord.
For completion of instruction in terms of discourse earlier orders, tinta order ase. Silver. There is Swencho. It is made clear that in the event no instruction is provided to the learned public prosecutor, office of the learned public prosecutor, this court may consider personal appearance of the officer in charge concerned. We need to finish it up. Maximum case, Mr. Das, those where by virtue of earlier provision that victim is to be or informant is to be made a party in all cases, no notice has been served. So what I am doing is just relying on that as per extent norm, this is not necessary. However, shall be at liberty to have. And division, and that is how we are finishing it up. Matters are years after years only for service.